The moment the judge cracked open that folder, something shifted behind his eyes, and every person in that courtroom felt it before he spoke a single word. He held the binder in both hands, thick, tabbed, rubber-banded across the spine. He scanned the front page. Then he looked at the woman at the petitioner's table, then at the older couple behind their attorney, then finally at me. When he spoke, his voice was deliberate, the voice of someone choosing each word carefully. Is it your understanding that the other party has reviewed what's in this file? I held his gaze and gave one small nod. What came after that nod ignited fast. The bailiff stepped forward. The woman at the petitioner's table was on her feet, voice splitting the quiet. The older woman behind her gripped the rail. And the man beside her, my father, dropped his eyes to the floor, the way he'd been dropping them for 11 years. But that courtroom moment. That was the ending. And endings don't mean anything without what came before them. The beginning was a Wednesday night in late winter. A doorstep. A carrier. And a child I had no reason to expect. Welcome to Quiet Justice Tales. I'm Claire, 36, a nurse at a regional clinic in Western Tennessee. 11 years ago, my younger sister left her newborn on my doorstep and vanished. My parents told me the baby was my problem. I raised her. I adopted her. And when all three came back a decade later demanding custody, I walked into court with something they hadn't planned for, everything I had documented. If you've ever been the person your family leans on right up until the moment you stop being useful to them, drop something in the comments. You'll want to hear where this goes. I was 25 that winter, coming off a 10-hour shift where dinner was crackers from the break room, and my uniform smelled like antiseptic and someone else's emergency. I pulled in close to midnight. My porch light was burning, it always was. I'd kept it on since the first week in that rental off Hargrove Road. Just habit by then. The carrier was sitting dead center on the mat below my front door. I dropped my bag and crouched. Inside the carrier, wrapped in a mint green blanket, was an infant. Weeks old, maybe 3. Fingers curled toward her palms, cheeks pink with sleep. The clinical part of my brain engaged automatically. I placed 2 fingers to her sternum. Counted. Regular rhythm. Good color. Fed recently, from the look of it. Then I saw the envelope tucked into the side pouch of the carrier, and I recognized the handwriting on it before I even pulled it free. My sister Danielle wrote everything in the same wide, looping cursive she'd used since junior high. Birthday cards she always forgot to send until 2 weeks after the date. Grocery lists she left on kitchen counters. That handwriting. Inside was a folded sheet of notebook paper, torn along one edge. 4 lines, her name is Maya. I'm not able to do this. Please don't try to find me. D. No date. No return address. No phone number. Just a name and an instruction. I stood up, looked both directions down the quiet street. A few windows lit. No movement. Danielle's car, the silver compact she'd been driving for years, was nowhere. I didn't know how long the carrier had been sitting there. Could have been 20 minutes. Could have been 3 hours. I lifted Maya from the carrier and held her against my shoulder. She stirred, made a small, uncertain sound, then settled. I called 911 with my free hand. Then I called my parents. My mother's voicemail picked up on the first try. And the second. And the third. My father answered on the 5th attempt, voice rough with sleep. I told him everything. The carrier, the note, the baby. There was a long quiet. Then he said, I'll speak to your mother, and ended the call. By the time the sun came up, I had driven to a 24-hour store in the next town and purchased formula and diapers, still in my work clothes. A borrowed infant in a carrier balanced in the cart beside me while the night shift cashier looked at me in a way I filed away, and did not think about again. I drove to my parents' house on County Road 7 at 8 in the morning. Maya was asleep in the back seat. Their place looked the same as always. White siding, American flag at the end of the drive, 2 old oak trees in the yard. I knocked. My father opened the door, stepped slightly aside. My mother appeared behind him. Arms folded. Expression set like concrete. She did not come forward. She did not look at the baby. Danielle made her choices, she said. We warned her about that man. She didn't want to hear it. That's not our problem to fix. Mom? This is a newborn infant. She is not our responsibility. She is yours, if you want her to be. But she's not ours. I looked at my father. His right hand rested on the door frame. His jaw moved like he was working up to something. Nothing came out. My mother pulled the door shut. I heard the lock click. I stood on that porch for a long moment, holding a baby who had nowhere else to go. Then I walked back to my car, and made 2 decisions before I'd even started the engine. I would contact Child Protective Services. And I would ask them to place Maya with me. The CPS caseworker came the following afternoon. Her name was Roberta Sims. Practical woman, mid-50s, reading glasses pushed up on her forehead, clipboard in the crook of her arm. She walked through my apartment methodically. Checked the smoke detectors. Tested the locks. Ran the faucet and held her wrist under it to gauge water temperature. Where would the child sleep, she asked. I showed her the second bedroom. Bare except for a chest of drawers and a folding chair. I can have a crib set up before tomorrow morning, I said. A colleague has one in her garage. Roberta wrote something, nodded. You're working full-time. Licensed practical nurse. Millbrook Community Clinic. She explained kinship placement. Maya could remain with me while the investigation was open. If Danielle didn't resurface and no other family members stepped forward, the pathway would lead toward formal guardianship. I signed the temporary placement papers that evening with Maya asleep in a borrowed bouncer beside my kitchen table. The first week was survival mode. Pure triage. I called my supervisor, Dr. Reeves, and asked to move to day shifts. She agreed immediately. The gym, takeout, and every streaming service were cut. Formula and diapers went into the budget. 4:30 became my anchor, coffee in the dark, Maya against my arm. One-handed everything. You do what the moment requires. Maya smiled at 7 weeks. Rolled over at 5 months. Said something close to mama at 10 months, and I chose to count it, regardless of what else it might have been. By her first birthday, we had a rhythm. Morning shifts, daycare, pick-up, dinner, bath, stories, sleep. The clinic staff gathered in the break room, with a sheet cake and wrapped onesies. One nurse pressed a gift card into my hand. I held it together until I reached the bathroom. Then I didn't. Every month I sent my parents an email. A photo of Maya. A brief update. A standing invitation, we are here, you're welcome whenever you want to come. My mother did not reply. Not once, across 8.5 years. My father replied once. 7 months in. She appears healthy. No follow-up. No call. No visit. I kept every email in a folder on my computer. I labeled it family. I tried to find Danielle. Called her old number, disconnected. Searched social media. Contacted high school friends. Filed an inquiry with the county sheriff. They had a missing persons report open, but Danielle had left voluntarily. No evidence of harm. No legal mechanism to force a search. She wasn't missing. She wasn't lost. She had simply chosen to be gone. At 12 months, I filed for temporary legal guardianship. An attorney named Sandra Fulton, who had practiced family law in our county for nearly 2 decades, took my case at a substantially reduced rate after I explained the situation in her office. She told me something I wrote on a sticky note and kept on my refrigerator for years. Keep records of everything. You cannot know when the people who chose to be absent will try to narrate a version of events that erases you. The first guardianship hearing was in the county family court. A small room. Drop ceiling, wood laminate walls, fluorescent panels that buzzed faintly when the ventilation cycled on. Sandra stood beside me. Maya was in her carrier on the bench gnawing on the corner of a soft toy, indifferent to everything legal and adult. Danielle had been served by publication. A legal notice printed in the county newspaper, the procedural equivalent of calling into an empty room and listening for an answer that doesn't come. She did not respond. Did not send a representative. Did not acknowledge the proceeding in any form. My parents had been formally notified. Their response arrived through their attorney as a written letter. Sandra read it aloud for the record. We do not object to the granting of guardianship. We request that no further correspondence regarding this matter be directed to us. The judge paused on the final clause. He looked at me over his reading glasses. The child's maternal grandparents understand they are removing themselves from this proceeding. They do, Your Honor, Sandra confirmed. He signed the order. Temporary legal guardianship of Maya Rose Carroll, granted to Claire and Carol. In the parking lot I sat, with the engine running and Maya asleep in the back. Not celebration, not grief. Just wait. A judge's signature behind something I'd already been carrying for a year. Then I drove to the grocery store, because we were out of bananas. The years that followed were shaped more by what did not happen than by what did, the emails continued. Monthly, without exception. Maya's second holiday season. Her first day of preschool. The Saturday she tumbled off the back step, and earned 4 stitches above her left ear. Over 9 years, I sent 94 emails. I logged every one. The responses, 1, from my father, month 7, 2 words and a period. She looks well. That was all. Danielle resurfaced twice. Year 2, a call from an area code I didn't recognize. Her voice was the same as I remembered, slightly clipped, always sounding like she was already on her way somewhere else. She did not ask about Maya. She asked whether I could transfer her $300 for a deposit on an apartment. Would you like to know how your daughter is doing? I asked. The line held quiet for 4 seconds. Then she disconnected. She called again the following year. Same shape of conversation. A number, a need, no questions about the child she'd left with me. That time I asked her directly. Danielle, she's walking. She's talking. She knows you exist. Do you want to be part of her life? Her response was sharp and immediate. You took what's mine. You owe me. I didn't match her volume. She's not a debt or an asset. She's a child. The call ended. Tennessee allows single-party recording. I had recorded both calls on Sandra's advice, logged each one, and noted the pattern. Danielle knew where Maya was and how to reach me. She made contact only when she needed something. She never once asked what Maya looked like, what grade she was in, or whether she was doing well. When Maya was 3, Sandra filed a petition for involuntary termination of Danielle's parental rights. Grounds, willful abandonment. Under state statute, that meant more than 6 consecutive months without meaningful contact, financial contribution, or any verifiable attempt to resume a parental relationship. Danielle had provided none of those things for 3 years. She was served by publication. Same legal channel. Same silence. The hearing was brief. The judge reviewed the case record, the CPS placement documents, the guardianship order, the contact log, Danielle's documented absence, her failure to respond to the petition. He ruled. Parental rights involuntarily terminated. Effective immediately. Danielle could have contested it. Filed an answer. Called a lawyer. Shown up with a plan, or even just shown up. She did none of those things. Adoption proceedings followed within a few months. Sandra handled the paperwork. At the finalization hearing, the judge, a woman with reading glasses on a beaded chain and a warm, unhurried manner, asked Maya whether she knew what was happening. Maya, 3 years old, held my hand and said, "I'm getting adopted by my mama." The judge smiled. Signed the decree. The record was sealed by court order. Claire and Carol, legal adoptive mother of Maya Rose Carol. That evening, the porch light was on when we got home. The same light that had been burning the night Maya arrived. I'd kept it on every night since, without thinking much about why. Habit, or maybe something close to faith. Maya was 3 years old and legally, permanently, entirely mine. She pressed her face against the screen door that night, and watched the light on the step. "Lights on, Mama." "Lights on," I said back. I was certain the hard part was finished. I was wrong. Here's what I've noticed about people who only show up when something's worth reaching for: they have very good timing. Maya at 8 was methodical, and quietly funny in a way that occasionally caught adults off guard. Her teacher called at the fall conference to say Maya had written a water cycle essay she described as technically accurate and genuinely moving. I framed it and hung it in the hall. Our mornings had a shape I could navigate with my eyes closed. Coffee on before 5. Maya into the kitchen in socks, hair still flat from sleep, climbing into her chair where her cereal bowl was already set. She'd eat and narrate her dreams in extraordinary detail, while I packed her lunch and drank my coffee standing at the counter. "I dreamed there was a whole city underground," she said one morning. "But the buildings were made of bread." Was it edible? Extremely. Our house was small. Same rental off Hargrove Road. 2 bedrooms, 1 bath, a backyard with a garden I'd started 3 summers ago. Maya's drawings were held to the refrigerator with alphabet magnets. The bookshelf in the living room was doubled stacked. We ate dinner at the kitchen table every night, and on Fridays we played cards and ate pasta. I had been promoted to senior nurse the year before. The raise meant dental and a savings account I added to monthly. Maya knew she was adopted. I'd told her at 5 in words she could hold. "Your birth mother wasn't able to stay. I chose you." She thought it over for a day and then informed me, "You're my real mama." She was right. I didn't correct her. That was the year a letter arrived from someone named Daniel Whitmore. He wrote in small, careful block print, the hand of someone who fills out invoices by hand. He was a carpenter and contractor in the Eastern County, he explained. He'd had a brief relationship with Danielle 9 years ago. She had ended it and left town. He hadn't known she was pregnant. He hadn't known Maya existed. A mutual contact, someone from a community group who'd known both of them years ago, had seen a photo I'd shared online from Maya's school science fair. The resemblance was enough to make that person reach out to Daniel. He was not demanding anything. He said so plainly, twice. He didn't mention courts or legal rights. He asked if I'd be willing to talk. I called Sandra from my car in the clinic parking lot before I'd even driven home. "He has no legal foothold," she said. "The adoption is closed and final." But if you choose to allow contact, that's entirely your decision. I thought about it for a week. Then I called Daniel and suggested we meet at a diner. He was 34. Broad through the shoulders, calloused hands, a quiet that read as deliberate rather than uncertain. He'd brought a photo of himself at roughly Maya's age. The resemblance was not subtle. Same wide-set eyes. Same line of the jaw. We arranged a DNA test. Results came back confirmed in 9 days. Daniel Whitmore was Maya's biological father. He didn't make a scene. He sat across from me at the same table and said quietly, I missed 8 years of her life. I'd like to do right by her, whatever that looks like to you. We set terms. 1 supervised visit per month. He would be introduced as Mr. Daniel. No expectations or pressure attached to any particular word. He agreed to each condition without pushback. Daniel showed up. Every first Saturday, rain or shine, work truck in the driveway, on time. He brought books about engineering and construction. Maya called him Mr. Daniel and interrogated him thoroughly about whether you could build a greenhouse that was also a climbing structure. With the right materials, he said, almost certainly yes. After 4 months, I allowed unsupervised visits at the park. After 8 months, Maya showed him her most recent report card without being prompted. He had it framed. Over the following year, Daniel's contracting business grew, not dramatically, but steadily, the way things grow when someone shows up for them consistently. A second work crew. A materials contract with a regional developer. He lived without excess, drove the same truck, ate lunch at the same diner. But he saved. One afternoon, while Maya played in the yard and we sat on the porch, he told me what he'd arranged. I set up an education trust, he said. $80,000 to start. Life insurance names her as primary beneficiary. He watched Maya chase something across the grass. I lost her first 8 years. I can't get those back. But I can make sure she has something solid under her, whatever happens to me. He had named me the sole trustee. Not Danielle. Not my parents. Me. His estate attorney had drafted and formalized the documents. He had also filed a notarized sworn affidavit, signed, witnessed, entered into the permanent record, stating that Danielle had abandoned Maya, that I was Maya's sole continuous caregiver, and that under no conditions, should the trust be redirected to any other party. I didn't yet understand how much those specific words would matter. 6 months after the trust was established, Daniel mentioned during a Saturday visit that he'd been having chest pressure for a few weeks. My nursing instincts activated before he finished the sentence. How long exactly? 3, maybe 4 weeks. Probably just the lifting. Call a cardiologist. This week. Not next week. This week. He laughed it off the way people in their mid-30s sometimes do with anything that sounds medical. 3 weeks later, at 5:40 in the morning, my phone rang. A man named Greg Owens, Daniel's work partner. Daniel had collapsed at a job site in the next county. Cardiac event. Massive. The paramedics had worked for 20 minutes. Daniel Whitmore was 35 years old. I sat on the edge of my bed and held the phone to my ear while Greg apologized for calling so early, as though the hour were the problem. From the kitchen I could hear Maya's cereal spoon against her bowl. I told her after school. She sat on the couch still wearing her backpack, and wept in that restrained, shoulder-shaking way that is somehow worse than any sound. She had known him for less than a year. But Daniel Whitmore had shown up every single time. And in that year, he had become someone she would grieve. The probate process took the better part of a year to settle, the final accounting of Daniel's estate, Whitmore Construction's assets, his personal savings, the life insurance payout, and the trust he'd seeded, totaled $263,000. I was confirmed sole trustee. Every document moved through Sandra's office. The estate was formalized. Closed. Daniel's obituary ran in the regional paper. The final line, survived by a daughter, Maya. I read those words twice. I felt grateful and hollow in equal measure. I didn't yet know that someone else was reading that same line, doing calculations. The weeks after Daniel's death were muffled. Maya went to school. Said good morning. But the spark was lower. She slept each night with the mint green blanket, worn thin now, patched in 2 places with mismatched fabric. She didn't care about the patches. She held that blanket the way you hold onto the last steady thing when a room is shifting. One night she climbed into my bed, something she hadn't done since she was 6. She pressed her back against mine and spoke into the dark. Mama. Why do people leave? I turned toward her and brushed her hair away from her face. Sometimes people aren't ready, I said. Sometimes they are frightened. And sometimes they simply don't get a choice. She was quiet for a moment. Mr. Daniel didn't get a choice. No. He didn't. She fell asleep with the blanket pulled up to her chin. I lay still for a long time, looking at the ceiling, managing 3 separate layers of grief at once, my own, Maya's, and the stack of probate correspondence on the kitchen counter that still needed filing. The next morning, I sat at the table and worked through every estate document. Every receipt. Every letter. Every form. My binder, the one Sandra had first told me to build 9 years earlier, had grown thick. CPS intake notes, placement records, guardianship orders, the termination decree, the adoption record, trust documents, Daniel's affidavit. 3 inches of paper. 3 inches of proof that one person had stayed. The formal letter from Daniel's estate attorney arrived 10 days later. It confirmed what I already knew, the trust, the amount, my role as sole trustee, but it also contained the original notarized affidavit, filed and stamped, now part of the permanent record. I read it in full at the kitchen table. I, Daniel Whitmore, biological father of Maya Rose Carroll, do hereby attest, Maya's birth mother, Danielle Marie Carroll, abandoned the child within weeks of birth. I did not learn of Maya's existence until she was 8 years old. Since becoming aware of her, I have maintained consistent contact and financial support exclusively through Claire and Carol, Maya's adoptive mother, who has provided sole, uninterrupted, devoted care across the entirety of Maya's life. The final clause, it is my explicit and unwavering wish that Claire and Carol remain Maya's sole legal guardian and sole trustee of this estate. Under no circumstances should custody or trust administration be transferred to Danielle Marie Carroll, or to the child's maternal grandparents, who disengaged from the child's life entirely and refused repeated invitations to be involved. He had underlined under no circumstances. Twice. I folded the letter. Filed it in the binder between the adoption decree and the trust confirmation. Locked the binder in the small filing cabinet beside my bed. Maya was doing homework in her room. The blanket was draped over the back of her desk chair. I read Daniel's words 3 times. Not because they surprised me. Because they felt like something I hadn't known I was being given. I still don't know exactly how Danielle found out. Sandra traced it afterward. Daniel's obituary had run publicly online. It included his full name, his business, and one line at the bottom. Survived by a daughter, Maya. Probate records in this state are accessible through the county court's public portal. Danielle searched the filings and found the trust summary, not the full document, but enough. The beneficiary's name. The approximate total value. She called my mother within days. I know this because my mother admitted it later in court, at a point when denial would have cost her more than confession. Danielle's call was direct. Did you know that Maya's father left her close to $300,000? My mother's response, by her own account, was 2 words, he did. The 3 of them met at my parents' house shortly after. First time Danielle had been there in nearly a decade. They sat at my parents' kitchen table, the same table I'd grown up eating breakfast at, and Danielle walked them through the numbers and the logic. If they could file for custody modification and succeed, if a judge reinstated some form of parental access, or revised the guardianship arrangement, they could then petition to restructure the trust. Family court had the power to redirect trust administration. And that would mean access. This was not a family reunion. It was a financial calculation. Danielle retained a family law attorney in the city before she ever reached out to me. His name was Martin Voss. Reputation for aggressive tactics. Expensive retainer. She was constructing a case before she ever appeared at my door carrying an olive branch. The olive branch arrived on a Saturday morning. Maya was at a friend's house for a sleepover. Danielle showed up without calling ahead. She must have expected Maya to be home, because the expression on her face, when she realized the driveway held only my car, was the first honest thing I'd seen from her in years. She stood on the front porch, the same porch, wearing a pressed cardigan and small pearl earrings, her expression arranged into something she'd probably workshopped in the car on the way over. I opened the screen door, but stayed in the frame. Claire, she said my name the way a person says it when they are still deciding what kind of conversation they want to have. I know how long I've been away. I know what I did. But I've changed, and I want a relationship with Maya. We are her family. Her real family. And that should count for something. The phrase landed in the air between us. I looked at her for a moment. You've been gone for 10 years, Danielle. You didn't call once on her birthday. Not once. Her jaw tightened fractionally. She recovered. Mom and Dad want to see her too. We've been talking as a family. It's time. Your mother told me that Maya was my burden. That was her exact word. People grow and change. Some do, I agreed. I'll think about it. Thank you for coming. I closed the screen door and watched through the mesh as she walked back to her car, a newer model sedan with city dealership plates, and sat in it for a minute before pulling out. I called Sandra before Danielle had cleared the block. Sandra listened, then said the thing that organized everything. If she has an attorney, she's not here for reconciliation. She's here for evidence that she tried. My mother called 3 days later. Her voice carried a warmth it hadn't held in 8 years, which was itself the most informative thing she could have communicated. Sweetheart, we've been thinking about reaching out. We miss our granddaughter so much. We'd love the chance to see her. Sweetheart. After 8 years of silence. I kept my tone steady. I appreciate that, Mom. Maya is doing well. I'm open to a supervised visit at a neutral location. Let me know if you'd like to arrange something. A long pause. Supervised. We are her grandparents. You also filed a formal request, in a court of law, to have no further contact. That request is on record. She did not have a response. Over the next 2 weeks, Danielle texted photos of items she'd purchased: a stuffed animal, an art set, a small backpack with Maya's name embroidered across the front in purple thread. For when we get to visit, she wrote. I didn't reply. I saved every image and forwarded each to Sandra. My father called separately, in a voice that sounded scripted, or read from something. Your mother and I believe it's time the family came together, for Maya's sake. We all have a role to play here. I've been saying the same thing for 9 years, Dad. The invitation was always open. He didn't have a response either. Sandra spread the texts, call records, and emails across her desk and drew a timeline. They are building a narrative, she said. The story they need a judge to believe is that they tried, and you shut them out. Every message they send is a future exhibit. Her instructions were precise. Reply to everything, in writing, politely. Accept nothing without conditions. Document that I was the reasonable party. Build the counter-narrative in real time. I followed every instruction. Each text received a measured reply within 24 hours. Each phone call got a follow-up email summarizing the conversation. The binder added another half-inch. They did not take the supervised visit offer. 3 weeks after Danielle's first appearance at my door, a process server knocked at 7:50 in the morning. Maya had already left for school. I answered in my work clothes, coffee mug in hand. The man handed me an envelope with the County Superior Court seal. Petition for custody modification. Petitioner, Danielle Marie Carroll. Co-petitioners, Ruth and Carol and Gordon James Carroll. I stood in the doorway and read the filing summary. Count 1, the respondent has systematically isolated the minor child from her biological family. Count 2, family reunification is in the best interest of the child. Count 3, co-petitioners have been denied access to their granddaughter by the respondent's conduct.